You can't keep getting away with this.
I don't disagree that
Okay.
that should go, but that
So-
was not something that I.
No, I know. I don't think that you intended to elicit that, but yes, I'm going to give a rebuke. Sometimes you need to just, keep your powder dry and not argue every single thing.
All right, y'all, we are back. First of all, thank you for watching. Please stop what you're doing. Just hit the like button. It only takes a second. You know, it helps the creators out and it helps you out because it helps us out. Now, if you have been waiting to see the prosecution get rebuked, today there was a formal rebuke. Judge Whitaker literally rebuked the prosecution in front of the jury on purpose. So if that's what you want to see, watch this video. I'm going to place a timestamp for that in the comments because this is going to be a longer video. So if you want to jump right to that part, I'll place this timestamp for what happened before it and what led to the rebuke plus the rebuke. Other than that, let's jump right into it. Again, comment, hit that like button, subscribe, share this video out, and let's go. Oh, and a quick note, there were audio problems on behalf of the audio at the court. These are not the issues from me.
Thank you.
So just bear with it. They'll last for a few minutes and they'll be
Sage.
gone. But
Would
just
you please
FYI.
tell the jury on December 28th, 2022, what three members of YSL that you knew who had committed crimes intended to increase the notoriety, street credibility, and reputation of YSL?
Me, Gonatan, and Zachary.
And how was it that you personally intended to increase the notoriety, street credibility, and reputation of YSL through the commission of those crimes that you're talking about?
Could you say that question in another fashion?
Yes. As it relates to you personally, how did you intend for your crimes that you're talking about to increase the notoriety, street credibility, and reputation of YSL?
How would I put this? I couldn't say if it was the credibility of YSL. I would say the incident that happened.
I understand what you're saying, but did I correctly understand you to say that the three people you know who have committed crimes? I'm trying to gain clarity, so
Overall, she's asking if she's got it right.
thank you. Did I understand you to say that the three people who have committed crimes intended to increase the notoriety, street credibility, and reputation of YSL are you, Mr. Garlington, and Mr. Zachary?
Yes.
I won't ask you to speak about anyone but yourself. So as it relates to you, how did you intend for your crimes to increase the notoriety, street credibility, and reputation of YSL?
I don't understand that question, Ms. Lee.
Is this the first time that you have been faced with that type of question?
Yes.
have you ever asserted that Young Slime Life, aka YSL, is an organization made up of 3 or more members or associates who share common identifiers that include but are not limited to colors, hand signals, and terminology, who have committed crimes intended to increase the notoriety, street credibility, and reputation of YSL? Have you ever made that assertion in your life?
Yes.
Okay. So when you made that assertion, are the 3 names that you just gave the jury the 3 members of YSL that you were referring to when you made that assertion?
Yes.
Okay. So, as it relates to yourself, how did you mean for your crimes to increase the notoriety, street credibility, and reputation of YSL?
I'm confused on that one, Miss Love. I ain't gonna lie.
I'm sorry,
I'm confused on that one. I ain't gonna lie.
what are you confused about?
I'm confused on what you asked me.
Which part are you confused about?
You saying to increase, what crime did I commit to increase?
The notoriety, street credibility.
Oh, you saying what the crime did I commit?
My question is not what crime. My question is, how did you mean for your crimes, whatever they were, to increase the notoriety, street credibility, and reputation of YSL, no matter what they were? How did you mean for those crimes to do that thing?
I wouldn't say increase the game for YSL. I would say what I'm trying to get at is like things happen and I reacted.
And
I don't think it's what you're saying. I just don't think it was all about YSL. That's what I'm saying.
are you referring to one specific incident?
I only know about one incident, what I pleaded guilty to. I don't know about no other incidents.
Okay. So when I speak of street credibility, what do you understand that to mean? Is it the same thing for you as fame?
I never really been into that, Ms. Love, about fame and street credibility.
That's okay. But I need you to answer the question. What do you understand street credibility to mean?
I'm stuck, you know.
Why
I'm
are you
stuck
stuck?
right now because I don't understand what a street credibility is.
Do you know what fame is?
Yeah, I know what fame and street credibility, but I'm a person like, I don't go off fame and street credibility. I'm just basically, I believe in being a man, put it like that.
I appreciate that. What do you understand reputation to mean?
You're trying to uphold a reputation, right?
I can't give an answer. You have to give the answers, okay? What do you understand reputation to mean?
A name in the streets.
Okay. So how did you intend for the crimes you committed to boost YSL's name in the streets?
What's the name of it? trying to think how to answer this question.
Just tell the truth.
I'm going to tell the truth. I don't know but the truth. I'm just trying to think of a way of saying it with the truth.
Just say whatever's in your mind right now.
Ain't nothing in my mind right now but what I say.
Okay. Do you need a minute?
Yeah.
Okay.
Could you come back to that one?
No.
To boost the name or the reputation of YSL in the street. That's a good one. I'm trying to think this, Lord, because I understand what you're saying, but I don't understand what you're saying. If that makes sense.
What do you mean? You understand, but you don't.
Because you saying trying to boost the reputation of YSL in the street. Because I don't think anything I would have done would have been to boost the name of YSL in the streets.
Did you not mean to include yourself in the earlier statement that you made when you said YSL is an organization made up of 3 or more members or associates who share common identifiers that include but are not limited to colors, hand signals, and terminology, who have committed crimes intended to increase the notoriety, street credibility, and reputation of YSL? Did you not mean to include yourself in that group of 3 or more people, or was there someone else?
I included myself because I knew I committed a crime, but I wouldn't say the crime was just because the boosted reputation of YSL in the streets. It was about principle.
Okay. And when you say it was about principle in what way as it relates to YSL? Because that's what I'm talking about.
That's why the question is hard to answer, because you keep putting it as YSL.
Now, you said I keep putting it as YSL.
Yes.
Did you testify earlier that the statement that I read to you during my question is a statement you made? Did you make that assertion on December 28th, 2022? Is that something that you said yes to?
Yeah, but I didn't make that question or the answer. That was your question and your answer. And when I was trying to correct you on that, you wouldn't let me correct you on it.
Now you're pointing at something that may or may not be referenced in a moment.
Yeah.
But let's just talk about what you just said. You said that was my question.
Yeah, I did initially.
You said that was my question and my answer.
Yes.
When you say my answer, what do you mean?
The answer of the question. You just said, like, that question you asked me, it already had the answer on it, and I initiated.
I'm sorry. Are you saying that there is a question on some form that I gave to you?
Yeah, it sounded like a question and an answer already on it.
Okay.
Could you repeat what you said?
Yes. My question to you is, on December 28th, 2022, my first question was, what 3 people who were members of YSL did you know about?
I said me, Gonzalez, and Zachary.
Who had committed crimes intended to increase the notoriety, street credibility, and reputation of YSL. And you said you, Garlington and Zachary.
Right.
And my question to you was, how did the crimes that you committed, let's use another word, how did those crimes make YSL more popular in the streets?
You saying crimes, and I'm saying there's only one crime that I committed. You saying crimes, you using more than one crime.
Okay, so we'll say crime. How did the one crime you are talking about right now make YSL more popular in the streets?
I don't think it made YSL more popular.
Okay. How did it increase the notoriety of YSL?
I don't think it increased it either.
How did it improve or increase YSL's name in the streets?
It didn't improve or increase YSL name in the streets.
How did it boost the reputation of YSL?
It did not boost.
What now?
It did not boost the whatever you just said of YSL.
Okay. And how did it improve or increase the street credibility of YSL?
It didn't do that either.
Is it your testimony today that you know of no one who committed crimes intended to increase the notoriety, street credibility, and reputation of YSL? I need to understand that.
The crime that were committed, I don't think it was to do nothing with YSL, to boost the credibility of the street. There was none of that.
I'm not talking about crimes that weren't done to increase the street credibility, notoriety, and reputation.
What I'm saying to you.
Hold on. Let me just ask the question. I'm not talking about crimes that were not done.
Your Honor, I'm going to object, asked and answered. He's answered this question.
Overruled.
I'm not talking about crimes that were not done to increase the notoriety, street credibility, and reputation of YSL. So we can put all of the stuff that wasn't done for that purpose out of your mind. Just tell the jury, how did you intend for the crimes that were committed to increase the street credibility, notoriety, and reputation?
Your Honor, I'm going to object. That's facts, not evidence. He has repeatedly said there were no crimes committed, and she is assuming crimes were committed on behalf of YSL in her question.
Sustained.
Is it your testimony today? Let me rephrase. Do you know of 3 or more members or associates of YSL who have committed crimes intended to increase the notoriety, street credibility, and reputation of YSL?
No.
Okay. Do you consider yourself a member or associate of YSL? Either one, either a member or an associate of YSL.
I plead guilty to affiliated to YSL.
Let's put that out of your mind. I'm asking you here today, right now, do you consider yourself a member of YSL? Let's break it down.
Yes.
Okay. And on December 28, 2022, did you consider yourself a member of YSL?
Well, that's what y'all had me charged with.
We know.
Yes.
That's not
yes. Yes. Yes.
Okay. And how long have you been a member of YSL?
I don't recall exactly how many years it's been.
Do you remember what year you first became a member of YSL?
No, I don't remember the year that he first started saying what I said. I don't remember.
Would showing you a document with your writing on it and a year on it that you signed on December 28, 2022, refresh your memory?
Yes.
Your Honor, I'm going to approach the witness with what I will mark as State's Exhibit number 444 Yankee. And I will show it to counsel for either the defendants who wish to see. So page 3 of 7. And the second blank under section 4. And my wonderful team has come through and I have a paper. So I'm going to show you what has been marked State's Exhibit 444 Yankee. And I'm going to turn to page 3. Do not read any of this out loud.
Right.
I'm just going to point to the second blank under section 4 and ask you to read it. Does reading the second blank of the third page of 7 on State's 444 Yankee refresh your memory? Don't read it out loud.
Yes.
So, Mr. Sledge, would you please tell the jury how long you have been a member of YSL?
It's associated 2012.
Okay. When you say it says associated, what are you meaning?
That's what the plea agreement said.
We'll get to the document itself.
Right.
Right now, I'm asking you, since you've testified that you are currently a member of YSL, how long have you been a member of YSL?
Since 2012.
While associated with YSL, while a member, what have you done to support and express loyalty to YSL that was against the law?
When I pleaded guilty to a drive-by shooting.
I'm not talking about pleading guilty. I'm asking you specifically to please tell the jury what crimes have you committed to express loyalty and support to YSL?
That's an answer, John.
I just answered. I just answered.
I need you to expressly tell the jury what crimes you have committed to express loyalty and support to YSL.
I don't remember exactly all of them, but I know aggravated battery was one of them. Aggravated assault. Could you refresh my memory? Because I don't remember all the charges I had. There was a lot of charges.
Do you remember what you did, though?
I drove a car.
So how, when you say you drove a car, how does that lead to your committing aggravated battery and aggravated assault to express loyalty and support for YSL?
I wouldn't say YSL. I say it was basically Happy Demiki Gunner and Quindarius Zachary.
have you ever stated that you committed a drive-by shooting to express support and loyalty to YSL?
Yes, because I pleaded guilty in 2017.
Regardless of your guilty plea, I'm not talking about.
Well, that's the reason I signed that question.
Okay. So since I haven't referenced a question for the jury, I'm trying to keep the record clear, okay? I'm just asking you about acts that you committed that were done to express support and loyalty to YSL.
I just said.
Hang on a second.
Third question, ask the same question. The gentleman's given the same.
I'm going to let her proceed with this.
So you may go ahead. How does driving a car lead to committing aggravated battery and aggravated assault to express loyalty and support for YSL?
You losing me because I understand what you're saying, but what I'm trying to say, it probably was for people who claim to be YSL, if you want to use that as a refer.
I understand that you understand what I'm saying, but I'm asking for the jury's sake, okay? If you can just tell them how driving a car leads to an aggravated battery and an aggravated assault committed to express loyalty and support for YSL.
So you want me to explain to what happened?
I want you to explain how one leads to the other, how it leads to expressing support and loyalty for YSL.
I don't know, my love. I don't even think when I read the plea agreement, I was understanding it. I think I was just signing.
I want you to put out of your mind any agreement, and I'm asking you here today.
In no way, then.
In no way?
No way.
So who is it that you know who committed a drive-by shooting to support and express loyalty to YSL?
I already answered that question for you.
Would you answer it again then? I might have missed it.
Me, Garlington, and Zachary.
So given that you, Garlington, and Zachary committed a drive-by shooting to support and express loyalty to YSL, please explain to the jury how you personally intended for that criminal act to express loyalty and support for YSL.
I already told you, the one to express for YSL. It was just an incident. You making it seem like the crime we committed was for YSL. Yes, I did sign that. I understand what you're saying. I initiate on that question. I'm most definitely initiate on it.
Mr. Slade, since you're referencing that, and by that, just for the record, I believe that you're referring to 444 Yankee, the document that I just brought to you.
Yes.
Let's talk about that for a little bit, okay?
Yeah, go with that.
Earlier this morning, you asked if you could be allowed to speak with your attorney. Did you not?
Yes,
Did you get a chance to speak with your attorney?
yes.
How long have you had that attorney?
You said how long have you been my attorney, period?
Yes.
I don't know, a lot of years.
Does a lot of years mean more than 5?
Yes, more than 5.
Does-
Probably 15 or better.
And is it a safe assumption to say that you trust your attorney?
Yes,
Okay. And since you're referencing 444 Yankee and you're referencing signing it, did you have access to your attorney at the time you signed it?
yes. But also, when I brought to my attorney attention about that document and told him that that wasn't correct, he came back to me and told me, you said initial, and then I'll be able to explain when I come here today.
Mr. Sledge, please tell the jury whether you requested certain items that were different than what is contained in 444 Yankee to be either changed or removed from that document before you signed it.
When I tried to get it changed, he came back to me and said that you wouldn't change it. Them is exact words to me. When I brought a concern about it, he came back to me and said, you wouldn't change it.
Mr. Sledge, do you understand the question that I'm asking you?
Yes.
Would you please tell the jury whether there were changes
No, it
to
was no
this
change.
document
There was no change.
that you personally requested through your attorney?
Yes, and you didn't change it.
Is it your testimony that no changes were made to that document
No change was made to my
from
document.
its original form?
No.
I'm going to show you just. Now, are you saying no, definitely, or no, you don't remember?
I don't remember, but I think most definitely you didn't change it.
I'm going to show you page 6 of 7 on states 444 Yankee at section 5. If either
All right.
council needs to see it, I'd like to.
Yeah, right.
You may.
Okay.
Yes. Can you step outside into the hallway, please?
I believe that the question that I was asking you had to do with your ability to ask your attorney about any documents that you signed on December 28, 2022.
Right.
Did you have access to your current attorney on December 28, 2022?
Right. Yeah.
And did you have an opportunity to ask him questions before signing any documents presented to you by the state?
Yes.
Did you ask him questions before signing any documents?
Yes.
Did you request changes to documents that were presented to you by the state?
Yes.
Do you recall what changes you requested?
No, I don't recall exactly, but I know most of them.
Did you have an opportunity to ask your attorney what words within the documents that you were looking at meant? In other words, if you didn't understand something, were you able to get clarification about it from your attorney?
She's not asking the substance, so Overruled.
Did you refer the question? Ask the question.
Yes. Did you have an opportunity to ask your attorney about parts of the documents presented by the state that you didn't understand, if any such parts existed?
Yes.
Did your attorney explain those parts to you?
Yes, to his best ability, yes.
Did you have an opportunity to request changes to those documents from the state?
Well, I know he presented it to you, but I still say, from my knowledge, the ones that I wrote changed, you didn't change.
Do you recall ever receiving a document with the assertion that immediately after the murder of Donovan Thomas Jr., defendant and other YSL associates met at the McDonald's on Cleveland Avenue in Atlanta, Georgia?
I received a document, but I wouldn't know that because I wasn't there.
You weren't where?
At the McDonald's, where you talking about? So I wouldn't know that.
Did you convey through your attorney to the state, I can't initial that because I wasn't there?
I don't recall.
Okay. Was showing you a document with those words on it and a subsequent document with them changed refresh your memory?
Even if you show me the document with my initial on it, I still wouldn't know because I wasn't there. I don't know. I wasn't there. You can't make me know.
That's
if
not
I
the
wasn't.
question she's asking. Listen to the question again.
If she refers, she can show me.
Did you, my question is not whether or not you were there. My question is, did you receive a document that initially had that language on it?
Yes.
Did you make it known to the state through your attorney that you were not at the McDonald's?
Yes.
Did you make it known through your attorney to the state that that language needs to be changed or taken off that document before I sign it?
I don't remember if I did or I didn't.
I'm going to show you states 444Y. And I'm going to ask you, it's page 4 of 7 for the court's purposes and defendants, to read to yourself number 7 on page 4 of 7. Have you had an opportunity to read number 7 on page 4 of 7?
Yes.
Does that refresh your memory about whether or not language was changed to reflect that you were not at the McDonald's?
Yes, let's say I wasn't there.
Is that a change that was made at your request?
I guess.
Okay. Do you recall reading a document that had the language on January 10th, 2015, after the murder of Donovan Thomas Jr., defendant and other YSL associates gathered at the home of Jeffrey Williams, aka Young Thug, after leaving the McDonald's on Cleveland Avenue in Atlanta?
I don't remember signing that.
Understood. That's not the question. Do you recall seeing a document with that language in it?
No.
Okay. Your Honor, I'd like to to refresh the recollection of the witness, what I will mark as State's Exhibit 444 Bravo, and I will give a copy to counsel for the defendant, either one of them.
All right.
444 Yankee Bravo.
Okay.
I'll just wait up here. Showing you States 444 Yankee Bravo, would you read number 6, not out loud, to yourself on page 3 of 6?
I see it, but
Okay. And do you see, or does that refresh your memory as to whether you saw a document with that language in it?
I don't remember seeing the document with that.
Okay. Let me now show you State's Exhibit 444 Yankee.
You be wherever you want to be. Unless, can y'all hear her okay? Okay.
Mr. Sledge, having looked at State's Exhibit 444 Yankee, the document that we referred to prior to lunch, is your memory clear on whether or not it says that you were at the McDonald's on Cleveland Avenue in section 7 of part 4 of this document?
You said it say I was at the McDonald's.
No. My question is showing you States 444 Yankee.
Right.
Is that the document that you signed? Hold on.
I don't remember when I signed.
Hold on.
I see my initial, but
Okay.
I don't.
Do you also see your signature?
I said I see my signature.
Okay. With the date?
Yes.
All right. Of December 28th, 2022?
Yes.
Okay. Now, on this document that you are looking at, can you read to yourself number 7?
Yes. I read it already.
Okay. Having read that document, are you able to tell the jury if the document that you put your signature on December 28th, 2022, said that you met at the McDonald's or something different?
It says something different.
And Was that something different language that you asked the state to correct? In other words, does the document?
I don't, by me signing it, say no, but I don't recall if I asked you to change it. I was asking you so much to change that never got changed, so I don't recall which ones I asked you to change.
All right. Since you said you were asking me so much to change that never got changed.
Overruled.
Are you able to tell the jury what all you asked to be changed that did not get changed?
I just told you I don't remember. The Lord, that been almost 2 years ago. I don't remember.
Okay.
Not that part. Not by signing.
Would looking at 444Y refresh your memory at all?
Yeah, you showing it to me, and I told you my signature on it. You showing me that, and I'm telling you that it's saying my signature on it, but I signed. I ain't saying I didn't sign. I'm not arguing with you or debating with you about that. I'm not saying I didn't sign. I just didn't remember what I was signing. I just was signing.
Thank you for that. My question is, are you able at all to remember what things you recall asking the state to change that it did not change?
No
Objection asked and answered.
Well, can you rephrase that question? Because you've asked him the totality of it. Are you trying to ask him, is there anything that he remembers?
Yes.
Okay, try that.
Yes. All right. Thank you. Asking it in a better way. Is there anything you remember asking us to change that we just refused to change?
I can't remember exactly, but if you show me the paper, I probably can point out the ones that I wanted you to change that didn't get changed.
I'm going to show you states 444, and if you would not read anything, just tell me numbers.
I'm just pointing to you.
Okay. Go ahead.
Is this 444Y?
Yes, it is, Judge.
Your Honor,
Yes.
for the purposes of the record, I would just, I believe Mr. Sledge just identified one. If he could just say the numbers so we can follow, because we're not looking at the sheet along with him when he points.
Sure.
Number 8, number 9. I don't know if number 9. Because I don't remember.
I'm sorry, what did you say about number 9?
I meant number 7. I don't know. I know number 9 is one I asked you to change.
Did you say I don't know about number 7?
Yeah, I don't really remember about number 7, but I know what it's saying isn't true.
Number 7, you're saying is not true.
Yeah, I didn't hear that from that part. I heard it in the streets, not from a member. Do you understand what I'm saying now?
I hear your testimony, yes. Are those the only 2?
That's 3. Well, I said 7, I didn't really know. But 8 and 9, I most definitely remember asking you to change, and they never got changed.
Anything else?
No, not that I know of.
Now, when you say that you asked me to change 8 and 9, how did you make that request? Did you personally talk to me, or did you ask someone to tell me?
I was telling my lawyer those were not correct.
And he came back and, at your request, he asked the state, that's your understanding, to change those?
I don't know personally what went on between y'all. I wasn't there. I was in the back. Y'all was in the courtroom.
Now, at any time were you forced to put your initials on anything on this document that's labeled 444Y?
I was actually told you can initial, but you can get, if you be called in, you can explain the truth, what you know and what you don't know.
Is it your test? So are you now testifying that your initials are placed beside numbers relating to statements that are false? Is that what your testimony is?
Yeah, cause I don't know that. That's why I'm saying it's false. There's no way that I can know that if I wasn't there or no one who you have charged told me. I was personally charged with that same thing you talking about. From the beginning, before any of these guys, except Shannon Stillwell, any one of the other guys, before they was charged with it, I never heard of that until May 9th when you put it on your indictment.
Okay. I'm going to show you that same document, 444Y, and ask you to look at section 5 of the document. And looking at it, is there a marking on the document? Does it refresh your memory as to whether you personally marked anything out on the document?
I see my initial by whatever it is.
Does it refresh your memory as to whether you scratched anything out and changed it?
I think y'all told me to scratch that. I didn't change it. You wrote that. I didn't write that. That's not my writing. That's my initial.
Is that your initial? Okay.
Yes.
Is the change that you referred to on section 5 of page 6, is that the only thing that you recall being changed at your request?
No.
What else do you recall being changed at your request?
Well, now, yes, I don't, I'm sorry. Y'all can scratch. No, yes, I don't remember nothing else you changed at my request.
Would showing you any other documents refresh your memory?
No.
Okay. Three, on 444Y, which we were discussing before lunch. Can you explain to the jury how your participation in a drive-by shooting was intended to express support and loyalty for YSL?
I'm sorry, I didn't.
I mean, it has sort of been asked and answered in that he, sustained.
Tell us what happened in the drive-by shooting.
What you mean, go into details of what happened?
Yes, sir.
Well, I never, like, at the club, Garlington got jumped on. Which, the Michigan Garlington, which didn't have anything to do with anyone else besides me and Garlington.
How do you know?
Huh? How did
do
I
you
know
know?
they had nothing to do with no one else?
Yes, and yes.
Because no one else was in the club with us, got their hands put on me.
So, who was it that put hands on Garlington?
I don't know, it was a group of guys. I didn't see no faces, none of that.
So, how are you able to tell the jury that it had nothing to do with anyone except you and Garlington when you can't say who put their hands on you?
Well, I can say what Garlington told me, but I can't tell you, do I know it's personally was those guys? Because there was a lot of them, but I can tell you what Garlington told me.
Were those guys part of a gang?
Your Honor, calls for hearsay.
Well, I mean, it may or may not, to your personal knowledge.
Was
Did
they-
you believe that those guys who put their hands on Garlington were a part of a gang? I asked him,
Sustained. Rephrase your question.
to your knowledge, were the persons who put their hands on you, or on Garlington rather, excuse me, a part of a gang?
I don't know, because if they joined the game, I wasn't there when they joined the game.
If
So
they joined a what now?
if they was part of a game,
When you're saying gang, are you saying, spell what you're saying?
Gang. You
Okay.
said gang.
I did, thank you.
So if they was part of a gang, whenever they joined, I didn't eyewitness. So I don't know if they was or was they false claiming or what. I don't know.
Okay. So forgive me for interrupting. Please tell the jury what led up to the drive-by shooting. What happened?
Well, they jumped on Gunnington in the club. I assisted Gunnington. And then it went farther with us fighting. And then I don't know what happened on the outside. I don't know what happened on the outside, but then me, Gunnington, and Zachary, we went and we did what we did.
Okay. Were you standing next to Garlington when he first got jumped?
No, he was coming back towards me.
And you said you didn't see the face of who jumped him.
I never really seen it. Somebody told me that they was jumping on Gunnington.
Who
And-
told you?
People in the club. I can't give you a name because I don't know their name.
So what did you do?
I assist Gunnington.
How did you assist Garlington?
I helped get him off Gunnington.
As you were helping getting them off of him, did you recognize anybody that you were helping to get off of
It
him?
was abroad. No. There was so many people.
Okay. You said earlier that you didn't know whether these people were actually a part of a gang or if they were false claiming.
Right.
Do you know what gang they claimed to be a part of, if any?
Maybe ask another foundational question first.
Are you aware of whether these people that you pulled off of Garlington claimed to be a member of any particular gang?
You said, did they claim to be part of a gang?
Correct.
Overruled.
Actually, I can't really say what gang they claim.
Without saying what gang, at the time that you pulled these guys off of Garlington, did you believe that they belonged to any particular gang?
Overruled.
No.
Are you familiar with a person by the name of Kelvin Watts, who answers to the names Kel and Shell Kel?
I know of him, but I don't know him. He wasn't there though that night. I know that much.
Does Shell Kel, to your knowledge, belong to a particular gang?
Well, I heard that he was part of a gang.
Are you aware of whether he claims to be a part of that gang via his postings or anything else?
Yeah, a lot of people claim to be some they ain't.
Fair enough. What gang do you understand Shell Kel to be a part of?
What he claimed, 9 Deuce or something like that.
Nine Deuce?
Yes.
Is that also If Gang or Inglewood Family?
From my understanding.
That's a yes?
Yes,
your
from my understanding.
Okay.
I don't.
And is that gang, to your understanding, a blood gang? If he knows, Your Honor, I'm asking to his understanding, does he understand that gang to be a blood set?
Overruled.
Yes, I heard, but I don't know for sure. I heard.
Did you consider that gang a rival gang?
Please use your mic. Sorry.
A rival gang? No.
Did you state on December 28th, 2022, that you threatened to harm a person named Kel because of that person's association with a rival gang?
Yeah, but at the time I didn't know. At the time that the threat was made, I didn't know he was If gang.
When did you learn he was If Gang?
Ooh. I know it was after that video.
Okay. Now we're talking about a video. What video are you referring to?
The video of me and Quindarius. But it wasn't about no gang situation.
What did you do in the video?
I told him if he was looking for me, I had something for someone who was looking for me, who was not my friend.
And forgive me, you told him that if he was looking for you, what was that last part?
I had anything for anybody who's looking for me that's not my friend. He have no reason looking for me if he's not my friend.
Okay. And what did you have for him?
Whatever to do to protect myself.
Who else was in the video with you?
Quindarius Zachary.
Is he the only person?
That's the only person I remember.
I'm going to show you what we have marked as State's Exhibit 441Y, which has also been provided to counsel for the defendants with the court's permission. May I approach?
You may.
Are you able to see the video on the screen?
Yes.
Okay. And when do you recall that video being made?
I can't recall. I just know it was in. I can't recall. I know it was in. I think it was in 2015 or 2014. I don't recall.
What did you do with that video once it was made?
They posted on social media.
Who is they?
I want to say Zachary posted. Or did I post it? I don't recall who posted, but.
It was either you or Zachary?
Yeah.
What are you saying in the video?
I just told you what I said.
Is State's Exhibit 441 Yankee, is that a fair and accurate depiction of the video that you...
The video you just showed me?
Yes.
Yes.
Your Honor, the state tenders 441 Yankee as evidence.
Admitted.
And with the court's permission, while we are pulling that up, I'll go ahead and ask you additional questions.
That's fine.
Thanks. Do you have anything in your hands in the video?
Yes.
What?
I'll go.
And does Zachary have anything in his hands in the video?
Got 2 guns in his hand.
What was the purpose of posting that video on social media?
We were really being silly, man.
Okay. And when you say you're being silly, what do you mean?
It was childish.
Did you intend for people to see it?
They posted on Instagram, so of course people were gonna see it.
Understood.
We posted it for him to see it.
Would you please continue? Hang on one second. If it's ready to play, we can play it. And we are now publishing State's Exhibit 441 Yankee after we hide the floating toolbar.
Little stiff ass nigga. We ain't really going back and forth no nigga. You little bitch ass nigga. I know who you hit. I'm everywhere. Yeah, fuck you nigga, Chair. Whoever else, nigga. Well, nigga. Pop, nigga. Whoa. They said I ain't really going back.
Is that the video you're referring to?
Yes.
All right. Now, would you continue telling the jury what led to the drive-by shooting following Demekion Garlington getting jumped on at the club?
What led to it?
Yes, continue telling us what happened.
We left the club and we went over. Well, no, we didn't leave the club. I left the club and then Garlington called me to come back to get him because I left him at the club.
Did Garlington ride with you to the club?
No.
Do you know who Garlington went to the club with?
No, he was calling me all that day to ride me to the club, and I don't like people to ride to the club. I mean, I go to the club by myself. I might meet them there, but I always ride by myself.
Who all participated in the fight when Garlington got jumped?
Just me and Garlington. No one else was in the club with us.
All right. And so after, how did the fight end?
Security guard broke it up.
Okay. After the security guard broke it up, what did you do?
I stayed in the club. They put Garlington out the club.
Mm-hmm. And then what happened?
I was in the inside looking for Garlington's phone with security guard, and I guess security guard found the phone and he took it outside. And then eventually I got the females that I was with and we went outside.
And then what happened?
I pulled off. Garlington was talking, saying something, and I got in my car and pulled off. And by the time I got to the spreadway, Garlington called me back to come pick him up because he didn't have a ride.
What club were you all at?
Club Crucial.
And what day of the week was that?
It wasn't a Monday, so it had to be like a Saturday or something like that, if I am mistaken.
What did Garlington call you back for? Just to get a ride?
Yeah, at first just to get a ride, yes.
What then did it later turn into?
It later turned into a shoe.
Tell the jury how that happened.
I guess Garlington didn't want to let it go, and I was riding with Garlington. Which I probably wouldn't have let it go neither, because another grown man ain't got no business putting his hand on no grown man.
So fill in the blanks and tell us, from the time that you went to pick up Garlington, what happened that led you to participate in a drive-by shooting?
I don't remember. I can't remember all the details that happened that night, but I just know it was a drive-by shooting. Well, it wasn't a drive-by shooting.
What
It
was
was a shooting. Because I didn't see nobody shoot. If that makes sense.
Please explain.
I never seen them shoot. Because I dropped them off and I kept going.
And then what happened?
I guess they did the shooting.
Did you drop them off at any one particular spot?
I don't know the name of the street.
Understood, but did you drop them off at any one particular spot?
I don't remember.
Did you take them to more than one spot?
Can you refresh my memory if you can?
Let me try this another way. Were you asked to take Demekion Garlington or anyone else in the car with you to more than one spot?
No, I remember taking Zachary, to his cousin's house somewhere.
So what happened at the spot that you said you dropped them off at?
I don't really remember, Ms. Love, but I know I pleaded guilty to it. I don't remember, but I know I pleaded guilty to it. I don't remember all the details, but I pleaded guilty to it.
Mr. Sledge, is a drive-by shooting or shooting something that stands out in your mind, or is it something that's just commonplace for you?
Could you repeat it?
Is a drive-by shooting something that stands out in your mind, or is it something that is just commonplace for you?
Could you break it down? Because I don't understand what you're saying. You saying, is it in my mind or is it just something I do?
Is it something that is worthy of remembering for you? A drive-by shooting?
No.
It's not something that's worthy of remembering?
No.
Okay. So it's not a big deal for you?
Not for me.
Was more than one house shot up after Demekion was jumped at the club?
Probably I wasn't there. I probably was, I'm saying, but I didn't take him to more than one place.
Do you recall going to Adele Drive?
Where is that located?
Off of Martin Luther King in... I'll rephrase. Do you recall going to an area off of Martin Luther King called Adele Drive?
Yeah, I think that was one.
Do you recall going to a location on Drew Drive?
No, they lied. No, I don't recall going to Drive, but I know it was all in my plea agreement. I just thought it was best in my interest, so I pleaded guilty to it.
Okay. Did you ever talk about that shooting with Quindarius Zachary or Demekion Garlington?
What you mean, that night?
At any time?
No, we didn't really talk about it.
Okay. When I asked you whether you threatened to harm Kelvin Watts because he was affiliated with a rival gang, did you say at the time you made the threat, you did not know he was IF gang. Did you say that?
Yes.
Why did you make an assertion about IF gang when I asked you about a rival gang?
Because it ain't, Ms. Love, it ain't like I don't know what y'all trying to put together. I know what you saying and I know what the state's saying, but that don't mean it got to be true.
Mr. Sledge, do you understand that I'm just asking you questions so that you can speak to the jury?
And I answered to the jury like.
You didn't answer the question. My only question to you was, why is it that when I asked you whether you threatened to harm Shell Kell because he was affiliated with a rival gang, you responded, at the time I made the threat, I didn't know he was IF gang.
I said I didn't know he was 9 Deuce.
Object. That's a misstatement of the evidence.
Sustained. The witness corrected it.
Thank you. Why did you say that at the time you made the threat, you didn't know he was a member of that gang?
Because the state, this is what the state painted a picture that YSL, I'm answering the question if you're going to let me answer. The way I know the answer. If you're not going to let
Go
me
right
answer,
ahead, Mr.
then
Sledge. Go ahead.
because the state is painting a picture that YSL and 9 do is the rival game. So I know you saying it don't take a rocket science to figure that out.
Has anyone instructed you to come in here and talk about what picture the state is trying to paint?
No,
Has anyone instructed you just to be honest?
I'm being honest. You might think I'm not, but I'm telling you I'm being honest.
Okay.
I'm being honest as I can.
So irrespective of the picture that the state, in your opinion, is trying to paint, why did you bring up the name of that particular gang when I asked you about a rival gang?
It's
Now
also
it has been overruled.
it's also a misstatement, Your Honor. Miss Love brought up if gang.
Right.
Correct.
All
Go
right.
ahead, Ms. Love.
All right. How did Quindarius Zachary get in the picture
What you mean?
as it relates to this drive-by shooting on April the 28th? How did Quindarius Zachary get in the picture?
I don't know if Gunnington called him. I think Gunnington called him and told him he had got jumped on before I even made it back to Gunnington.
And so how did Quindarius Zachary get with you all?
What you mean? We went and got him.
Okay. So after you picked up Garlington from Crucial, you all then drove somewhere else and picked up Zachary?
Right.
Where did you all pick him up from?
I don't remember.
Who was it that told you which house or houses to go to?
I don't know who told Gunnington.
No, who told you you were driving, right?
Yeah,
Wait.
Gunnington told me how to get there.
Okay.
Love, they already have told you all this stuff. Well, you're right. You got to tell it to the jury. I'm sorry.
And you understand, I can't tell the jury.
Right. You're right.
Would you please tell the jury whether at the time you took Garlington to that house, you knew or believed that it was the home of a rival gang member?
Yeah, that's what I believe.
Did you see the guns did anyone have guns in the car at the time that you took Garlington to that house of the rival gang member?
We had guns. We roll with guns every day. Not one day, every day.
When you say we, who are you talking about?
Me, Gunnington, and Zachary then.
Okay.
Whenever we was together.
At the time that you were together, were Garlington and Zachary also members of YSL? Apologies.
Well, everybody probably assumed they was YSL, but I can't. Well, I heard them say YSL, put it like that. So I can't really actually say.
Was it your understanding at the time that you took them to that home of the rival gang member that both Garlington and Zachary were YSL?
I believe so, yeah.
How did Nine Deuce become a rival gang?
I have no idea.
Who was it a rival to?
You said, the state say YSL.
You're the only one that can give
Why?
testimony. So who was it a rival to with your understanding?
Well, from my understanding, it wasn't a rival with everyone who claimed YSL. There probably was certain people, not everyone.
So who was it a rival to? Who was this gang a rival to?
Me, Garnet, and Zachary at the time.
Okay. No one else.
Not that I know of.
Did you say on December 28th, 2022, that you and your fellow YSL associates committed the drive-by shooting on behalf of YSL and to increase the notoriety, reputation, and fear of YSL?
Again, that was some you stated and some I initiated. I most definitely initiated that.
Earlier, did I give, go ahead.
Because none of the stuff on the paper, I never approved none of it. I signed, but if you would have came to me and asked me that before, I would have told you it wasn't true.
Earlier, when we were talking about changes that you asked to be made, do you remember having an opportunity to look at the document that is labeled 444 Yankee?
To be honest with you, I didn't look at the whole document.
Okay. So if I give it back to you, will you look at each of the factual acknowledgments contained on the document?
I already told you, Ms. Love, I initiated on it.
That's not what I'm asking.
Yeah, I can
Do
look
you
at
need
it.
an opportunity to look back
I
at
can
it?
look back on it.
When you've had a chance to read each of them, would you just look up? Could you read each of the items under that section, please?
You just read them, Ms. Love. I am.
Do you not want to read them?
No, I don't want to read.
Why don't you want to read them?
Because I don't want to read. I just answer to you.
Okay.
I don't want to read.
Having had the opportunity to look at the factual acknowledgments, what other factual acknowledgments besides the one you listed as 8 and 9 are you now saying aren't true?
Your Honor,
Yes.
that is a misstatement of the evidence. He said that 7 is not true as well.
Yep.
Okay.
Sustained.
I'll rephrase. Earlier, did I ask you to identify which portions of the factual acknowledgement that you asked the state to change?
And I told you 8, 9, and I couldn't remember if I asked you to change some, but I know some is false.
Okay.
That's what I told you.
If you understood that you could ask me to change 8 and 9, would you explain why you did not ask me to change any other ones?
I can't say, my Lord.
Did the state force you to sign this document?
I was forced. I feel like I was forced myself.
I'm sorry, what did you say?
I feel like I was forced myself because I was going through something.
Explain what you're saying.
I was going through something with my mother being sick. I needed to get home to my mother. And if I went to trial, I couldn't afford Mr. Wright to go to trial.
Could you afford to ask Mr. Wright to make any further corrections to the document?
That Pacific day, Ms. Love, I was just trying to get home to my sick mother.
Did you swear under oath that each of these statements that you initialed were true?
Maybe. I don't even remember. I can't say. If that what it say, yeah.
Did you lie under oath?
No, I didn't lie.
Well, explain to the jury how they should reconcile those two statements.
I really can't explain it to you, Ms. Lord.
Did you sign a statement? Did you make a statement
I didn't. Go ahead.
That you have read and carefully reviewed the agreement that you were entering with the state, that you have reviewed and corrected where necessary for accuracy each statement contained in defendant's factual acknowledgments, and that you acknowledge the truth and accuracy of each and every statement listed therein, that you fully understand the agreement and have had an opportunity to discuss this agreement and each of its provisions with your attorney, Mr. Derek Wright. No promises other than those contained in the agreement have been made to you in furtherance of the agreement, and you freely, knowingly, and voluntarily enter into the agreement without force, threat, or coercion. Did you make that statement on December 28, 2022?
I think so.
Okay. Was that statement true or false at the time that you made it?
I don't know, Ms. Lord.
Why do you say you don't know?
I really don't. I just told you my intention was.
I understand. And my condolences for what you had to go through. But the jury needs to know whether that statement that you made was true or false. Would you please tell them?
I guess it was true if I made it, Ms. Lord.
Why did you pause so long before answering?
I don't know.
Now, you were talking about having pled guilty to charges related to the drive-by shooting or to the shooting on April 28, 2015.
I pleaded guilty.
Excuse me, Judge. At this time, can we get the instruction, please? That's the first question directly from the state.
Yes. Ms. Levis?
Yes.
Okay. All right. Ladies and gentlemen, you are about to hear evidence that a co-defendant in this case has pled guilty to some of the charges in this indictment. I caution you that this co-defendant's guilty plea conviction itself is only admitted for a limited purpose. That guilty plea is an admission by this witness only that he committed the criminal acts to which he pled. You are not to consider the co-defendant witness's guilty plea as evidence that any other defendant is guilty of committing any of the criminal acts alleged against them in this indictment. Each defendant is entitled to have the issue of his guilt determined solely on the basis of the evidence against him and not on whether another person has been convicted of the same charges with which the defendant is accused. If you find that the co-defendant witness provided testimony on the stand that is inconsistent with his guilty plea admissions, you may consider the witness's prior inconsistent statement that is, his guilty plea admissions, including to the allegations in the charges to which he pled guilty, as substantive evidence, which you may consider against any defendant currently on trial for whatever bearing it may have on the issues on trial.
Thank you, Your Honor. So, Mr. Sledge, you mentioned pleading guilty to charges related to the April the 28th, 2015 shootings that you were just talking to the jury about. Do you recall that?
Yes.
All right. And when you pled guilty, did you do so in 2022 or did you do so in 2015 or 2017?
Obviously, I pleaded guilty 2017.
Thank you for that. So, at the time that you pled guilty in 2017 to the charges related to the April 28th, 2015 shooting after Demekion Garlington was jumped, was there a factual basis given for that plea? Do you understand the question?
No, what you mean?
Okay.
I don't.
First, let me ask you, when you pled guilty in 2017, did you have an attorney?
Yes.
And is the attorney that you had then the same one that you have now?
Right.
And did you trust him then the way that you trust him now?
Right.
And at the time you pled guilty, did the prosecutor tell the court that the evidence would show that on April 28, 2015, Mr. Garlington and Mr. Sledge were at a club called Club Crucial on Donnelly Hollowell Parkway earlier in the evening when members of, and preface this by saying Mr. Garlington, Mr. Sledge, and Mr. Zachary at this time were members of a gang called YSL, or Young Slime Life, that at some point had been affiliated with the Blood Criminal Street Gang. There had been a falling out carrying from the fall of 2014 into 2015. This, for lack of a better term, gang war was going on at this time. Mr. Garlington was jumped at the club by members of a rival gang, Aaron Mills, Dominic Carter, and others that are members of a gang which is a subset of If Gang, or Inglewood Family Bloods, which is a gang that the dispute was going on with at that time, when Mr. Garlington was jumped and assaulted at the club. A decision was made by Mr. Sledge. They called Mr. Zachary, the co-defendant, to retaliate in some way. The evidence will show that Mr. Sledge drove the vehicle. Mr. Garlington and Mr. Zachary were inside with weapons, and they first drove by Adele Avenue, 1428 Adele Avenue in Atlanta, Georgia. And that location at the time is the home of Darren Mills and his mother, and at least one of his sisters and one of his cousins, and is an address that Darren Mills actually used and stayed at. He was one of the individuals that had assaulted Mr. Garlington earlier at the club. Mr. Sledge drove by and they shot at the house. There were not individuals outside of the house, but the house was shot. During the shooting of that house, Miss Denise Bell, who is the aunt of Darren Mills, while she was in her bed, sustained a gunshot to her buttocks and had to go to the hospital and had to have surgery. She was shot. The house was shot up, and there were other individuals there at the time, including Cecilia Davis and Diamond Mills. Diamond Mills being Darren Mills' sister. Also, the car belonged to Cecilia Davis, which was in front of the house and received damage. The evidence is that Mr. Sledge was the driver of the car. After that, Mr. Sledge drove over to 1903 Drew Drive Northwest, an apartment there was at the time being used by Philip Collins, who is Darren Mills's brother, and also present at the club and participated in the assault. In shooting at what they believed to be Philip Collins' apartment, they damaged apartments 1122 and 1120. Natasha Battle's apartment, which was 1120, her patio doors, windows, and couch were damaged from the gunfire. Ms. Troutman's apartment was 1122, and that was the other apartment that was damaged. Through investigations, detectives got a lead that Mr. Garlington and Mr. Zachary were involved, and they conducted interviews.
Yes, sir.
I can pause there.
Okay.
Was that factual basis? Were those words read to the court by the prosecutor at the time you entered a guilty plea in 2017?
I don't remember was it read by the prosecutor because I took a blind plea. And I think the judge read off the evidence. I don't recall what it was, though.
Okay. Do you recall hearing those words read by somebody in court as the reason or the factual basis for the charges that were being brought?
If I could explain, I pleaded guilty because I felt like it was in my best interest. You had two co-defendants. Some of what they said was true, and some they said wasn't true. But I did plead guilty because I felt like it was in my best interest.
Were you given an opportunity to say anything at the time that you entered that plea? Were you given an opportunity to make any statements?
No, not that I remember.
Do you recall the judge, after those statements were read, asking you, is there anything you'd like to say before sentencing? Do you recall that happening?
Yes, I recall him asking me that.
Do you recall telling the judge, no, sir?
I remember telling him, thank him for the plea that he allowed. I remember that. I remember me telling him, thank him for the plea that he accepted on the non-negotiable plea, the blind plea or whatever it was.
Would you explain to the jury what your understanding of a blind plea is?
A blind plea that I understood that you leave the evidence up to the judge and the judge determine on the sentence.
At any time, did you tell the judge, I'm not admitting this, I'm just doing this because it's in my best interest?
Well, I didn't tell the judge that. I told my attorney that. When my attorney asked me, like, when he came to me with the plea deal, and I told him, I said, why I take the plea? Because it's best in my interest. You got two guys against one.
Hold on. At the time that you...
No, I didn't tell it to the judge.
That wasn't my question.
Oh.
At the time that you pled guilty, did you know what sentence the judge was going to give to you?
No.
Okay.
Not like no, I just knew it was
Did the judge, was it explained to you that you could receive up to the maximum sentence on each charge?
not if I understand. I think a deal was already worked out, if I ain't mistaken. That what made me take it. I think it was already worked out between my attorney and the state.
Do you understand the difference between a negotiated plea and a blind plea?
No.
Okay. Have you done anything besides a blind plea in front of a judge before?
Yes, I think I have, yes.
And when you pled guilty on December 28th, 2022, was that a blind plea or something else?
I think it was just a plea. It wasn't a blind plea, though, if I'm not mistaken.
For a regular plea, what do you understand to be the terms? In other words, do you know your sentence before you plead guilty with a regular plea?
I don't know, because before the blind plea, I knew my plea.
Why did you then distinguish for the jury that it was a blind plea?
It was, but I already knew the sentence. My lawyer had already aware to me that they was offering the same thing. They was offering the co-defendants what they had pleaded guilty before me.
Okay.
So when I pleaded guilty, my lawyer aware me that they was offering the same plea deal that they gave them. But in my plea deal, I told my attorney that, like, I didn't want the probation. I just take the straight prison sentence.
Okay.
Yes, sir. All right, outside the presence of the jury? Okay. Yes?
Yes.
Okay. I'm going to excuse y'all to the jury room.
Your Honor, will the witness be excused?
Yes.
And Your Honor, may I first grab it?
To do what? Sure. Yes, sir.
Thank you, Your Honor.
Your Honor, I have a motion for a mistrial. The evidence has just come out that two co-defendants who, to my knowledge, at least one of them is not testifying and has entered a guilty plea. That is a confrontation clause violation to Mr. Williams and the other people on trial. In addition, Your Honor, gave an instruction with the last line, and I know it was objected to previously, but I want to stress this, that if it's a prior inconsistent statement, it can be used against Mr. Williams and the other people. That was premature, because I don't believe there's anything inconsistent as of now. And then the third reason I'm moving for a mistrial in the aggregate, Your Honor, is that the prosecutor uses and reads the statement of the then prosecutor, I believe it was the Honorable Mr. Bailey, who entered this plea and gave a factual basis. But she did not make it clear that the Honorable Derek Wright said on page 12 of this transcript to the same court that Mr. Sledge is tendering the plea under Alford, which is ALFORD.
Yeah, I'm seeing the same thing. And honestly, I thought that we were going to be dealing with the guilty plea that he took in this case. And yeah, that's problematic that this 2015 case is an Alford plea. And so I don't think that any of what I said with regard to admissions is actually true, even against this. I mean, he's saying he pled under Alford, and I don't know why the disposition sheet doesn't say that, but it is very clear that this is an Alford plea in this 2015 case. So Mr. Wright wants to share something. Yes, sir.
I was just waiting for the appropriate time that I was going to point out that it was in fact an Alford plea. So I thought her cross-examination was not appropriate.
Well, y'all, I mean, maybe that, yeah.
It was something other than an Alford. So
Well, maybe don't wait so long next time. But I mean, I'm definitely going to Ms. Love, do you want to be heard?
Yes, please.
All right, go ahead.
One, we'd ask that the court deny the motion for mistrial. Number two, we would ask, as it relates to the assertion that no inconsistent statement was made, in the factual acknowledgments.
Okay, no, see, that's the deal with an Alfred plea, is you are not acknowledging that the facts are true like you would in a regular guilty plea. You're saying, I think that the state has enough evidence that a jury could be convinced beyond a reasonable doubt that these facts are true. But you're not acknowledging on your own, yes, these are true.
Your Honor, when
Yes, ma'am.
I spoke of the factual acknowledgments, I meant 444Y.
Well, that's what I thought you meant.
Within 444Y, we referenced this particular
All right, let's,
section.
maybe if you can point me specifically, let me pull that one up.
Page
Which number? Go ahead.
number 3 on page 3 of 7, under defendant's factual, I'm sorry, not number 3, number 4, on defendant's factual acknowledgments, on or about April 28, 2015, as reflected in Fulton County Indictment 15 SC 138994, defendant and fellow YSL associates Demekion Garlington and Quindarius Zachary committed a drive-by shooting using the firearm defendant wielded in the video referenced in Part 3 of this section, targeting family members of a rival gang. Number 5, defendant and his fellow YSL associates committed the drive-by shooting referenced in sections 3 and 4 above on behalf of YSL and to increase the notoriety, reputation, and fear of YSL.
Okay, and so those factual assertions, what I read as the limiting instruction would be true for. But the factual basis that you just read out from the 2015 one, that's a whole lot more than what's in numbers 4 and 5.
Your Honor, in number 6, defendant admitted committing and was convicted of aggravated assault and participation in criminal street gang activity, among other charges, for his participation in the drive-by shooting referenced in section 3, 4, and 5 above.
Okay.
And so if I'll, of course, comply with whatever appropriate instruction that the court deems necessary to give as it relates to the conviction of this witness for 15 SC 138994, but given the factual acknowledgments that were made as it relates to 22 SC 183572, and the fact that this witness did not assert, even though the plea was given in his best interest, he was allowed an opportunity to say what he said here, and he did not say it.
No. When a defendant has an attorney who is saying, we are pleading this because we believe it to be in his best interest, the defendant does not then independently need to say, yeah, by the way, Judge, here's what Alfred means.
Understood.
So no. Are you going to tender for admission any part of 444Y?
Yes, the state intended to tender 444Y.
In its entirety?
Yes, I did.
Any objection to that being tendered or admitted in its entirety?
And if there is an objection to it, then
All right,
we would just...
let's find that out.
Okay.
I object at this point to the entirety of the document unless the state can give reasons for which parts of the document are admissible at this time. And if they're not tendering yet, I understand that. But I can't get around how we got here. You know, I'm trying to follow this factual basis, and I realize I asked Ms. Renard, R-E-N-A-R-D, for this, and we're in a different case.
Yeah, we are. So, I mean, we've been talking about these 2015 crimes, and we've been talking about, you know, what's been going on in this 22 indictment. So, I mean, I guess that's how it came about. But I wish we'd been a little more specific about it all beforehand, because, I mean, I noticed this morning that this was an Alford plea. And I would have had issues with, when you started reading out the factual basis, I'm thinking, well, is this some other case that I don't know about that's not the 2015 case and not the 22 case? Because we should have been reading the factual basis from the 2015 case.
Your Honor, the 2015 case, I understand what the court is saying. The 2015 case is one of the overt acts that we allege in the indictment. And as it relates to the defendant's conviction for the 2015 case, we believe that it would be appropriate is an appropriate matter for cross-examination, and it appropriately falls under the portion of the court's instruction where it tells the jury that the conviction itself is not to be considered as evidence. And to the extent that Mr. Sledge is asserting that he didn't do it, that he dropped someone off, that is what he asserted, by the way. He said that he was not present. He dropped him off, and it was only one house.
Well, we all know how party to a crime works. So, I mean, yeah, he said, I didn't shoot, but he did admit to being the driver.
And so, to the extent that he said that, the statement contained in his factual acknowledgement that he and fellow YSL associates, and I'd also point out that early on he made a very blatant, inconsistent statement that YSL is not a gang. And in this factual acknowledgement section,
All right, we're not going to use anything in the factual acknowledgement section of the 2015 plea.
No, in the 22 SC 183.
Okay, yeah, no. I mean, all of that is inconsistent with any of his trial testimony is fair game for you to tender for admission and for them to consider as substantive evidence against everybody. The issue we have that needs to get cleared up is that before I read this limiting instruction, I thought you were going to tender the guilty plea to this 22 SC case. And it turns out that you were talking about the 2015 case, which I understand you're saying we did part of that as, part of the 22 factual acknowledgements. So those factual acknowledgements in there are fine as well. When I say in there, I mean in this 22 case. But I'm going to have to clarify for the jury that what I told them about prior inconsistent statements
does not
apply, and that everything you just read from that guilty plea also needs to be disregarded.
So, Your Honor, as it relates to the court's instruction to the jury regarding the inconsistent statement not applying, we would only ask that the court specify that the court is speaking as to the factual basis that I asked the witness about in 15 SC 138994, particularly where he has testified and he pled in his best interest.
Okay. And you haven't tendered yet the 444Y. And so at the point in time when you tender that, then I'll say, okay, for this one, this
Okay.
is true.
I see what, yes.
Okay.
Yes.
All right. If anybody wants to suggest specific language, I'm willing to listen. Otherwise, I'm just going to kind of
And,
give it my best shot.
I would
and
like,
Your Honor, may I say one more thing?
Yeah.
Because number one, the court has previously instructed the jury that questions, and I understand the content of the question needs to be addressed. But given that the witness has testified that he pled guilty in his best interest, and given that he can also be cross-examined as to whether or not he can, he was asserting these things, we don't believe that anything beyond a instruction regarding the factual basis for 15 SC 138994 not being considered a statement of the witness is required.
Okay.
I just respectfully don't think that goes far enough. You have a prosecutor who's saying it's just a blind plea. She leaves out everything about Alfred. She elicits, and I'm not saying that she could have anticipated this, but her questioning elicits that a non-testifying severed co-indictee pled guilty also. That is a total confrontation clause violation. It's the second time.
All right. And that's Zachary and.
Well, Mr. Zachary, I anticipate may testify.
Right.
I don't know. He hasn't yet, but it definitely includes Mr. Garlington, who the state has said will not be testifying. And then, just for you to know, you were not here, but the predecessor judge permitted, over objection, the state to do the same thing. They did it with a Mr. Winfrey, just like the court reporter's last name. He's not going to testify. No one believes he's going to testify. The state doesn't say he's going to testify. And they got out that he pled guilty. So they're aware of all this. And in fact, the state elicited in that case that the gentleman, Mr. Winfrey, pled guilty to avoid plea. It was vacated by the Supreme Court of Georgia.
Yeah, I remember you.
So, and
Didn't
then
he enter another one after the fact, though, anyway?
5 years later, Alfred plea and said I'm
Okay.
specifically innocent.
Yep. All
I mean,
right.
it was a farce.
Right.
And
Okay.
and then the predecessor judge wouldn't even let me examine the witness. And Miss Love said that the witness I could call in my case in chief on direct. So the reason I'm bringing that up is this is not new.
Okay. What's your intention with regard to Mr. Garlington? Do you have any intention of calling him?
Your Honor, no. And Mr. Steele is absolutely correct in terms of the witness testifying about Mr. Garlington and Mr. Zachary and his doing that. There's nothing that indicates that the only reason he did that was because they pled guilty. So that is not, in other words, his statements that he gave to the jury about Mr. Garlington pleading guilty and all of that are not something that I asked him about or expected him to be talking about.
Right. Okay. But nonetheless, we have that now before the jury.
We would
So-
ask that the court tell the jury to strike, disregard, put out of their mind anything about the Mr. Garlington.
He can't keep getting away
Just
with
to
it.
say anyone other than the witness
He can't-
on the stand.
Okay. But Mr. Zachary is a witness.
I know that, but he hadn't been called yet, has he?
No.
So
no.
deal with it when he gets called.
Yes.
Yes, sir.
Your Honor, on behalf of Mr. Sledge, clearly at a jury trial, we are always assessing the credibility of witnesses. My client has now been impugned, or at least attempted to be impugned by the state by suggesting that either he should have been making a statement or his plea was something other, or that these facts are in fact his adopted, admitted facts.
I'm going to make it clear that that's not the case.
And that's where I want to make absolutely clear that he was right in the position he was taking
All right. Anything else before we get the jury back in? That is a great idea. Let's all do that. Or take that opportunity. Okay, that is denied.
17875 refers to statements of prejudicial matters, which are not in evidence. And the factual basis given or read by the prosecutor in the plea in the 15 SC case, while containing details that are not contained within the factual acknowledgments of 22 SC 183-572, it contains, it's about the same act, which in the factual acknowledgments for this case, the defendant says occurred. He admits and acknowledges that he, Demekion Garlington, and Quindarius Zachary committed a drive-by shooting at this residence, and that they committed the drive-by shooting on behalf of YSL and to increase the notoriety, reputation, and fear of YSL, and that he admitted and was convicted of aggravated assault, participation in criminal street gang activity, and among other charges for his participation in the drive-by shooting referenced in sections 3, 4, and 5. And given that this evidence will be properly before the jury, our position is that these statements, the questions that I asked, which contains the factual basis, the assertion about the factual basis in the 15 SC case, would not be a prejudicial matter. Though the factual basis is not in evidence, the fact of the shooting is not a prejudicial matter, which mandates a rebuke.
Okay. Well, the fact that a co-defendant who may not ultimately testify and who you do not believe will testify has pled guilty.
I don't disagree that that should go, but that was not something that I.
No, I know. I don't think that you intended to elicit that, but yes, I'm going to give a rebuke. Ms. Love, I mean, that's just what it is sometimes to be the prosecutor in a case. Gotta have a tough skin. Suggested language, Mr. Harvey or others?
Need for some smarter colleagues to give me some suggestions, which is everybody in these three tables.
And Your Honor, I'm still reading under the annotations of that particular statute regarding the rebuke
we also presented this, by the way, as a guilty plea, not as an offered plea. And we read a factual basis from something that's not in evidence. It is so highly prejudicial that we all made a motion for mistrial. A rebuke is in order under 17875, and I think the court in front of the jury can say, and I hereby admonish the state for bringing up these matters that I have just told you to disregard, and the state should not do that again.
Your Honor, what the annotations say is what the law forbids is the introduction into a case by way of argument of facts, not only not in the record, but that are calculated to prejudice the accused. And
all right, Ms. Love, I'm going to give some sort of an admonishment. And I mean, sometimes you need to just, keep your powder dry and not argue every single thing to the nth degree. I've already said I'm giving it. So I mean, I can grant a mistrial if you'd prefer.
Oh, no. we do not
Okay,
want a
then
mistrial.
maybe stop arguing at this point.
Yes, Your Honor.
Okay,
Will the court
Here-
prior to
go ahead.
bringing in the jury, would the court be willing to read the
What I'm going to
rebuke?
say, well, I don't know what the rebuke? I mean, it's probably going to be something to the effect of, after I explain to them what they're not to consider, I also admonish and rebuke you, Miss Love, to pay careful attention to how you ask questions and to what you put before the jury. Mr. Harvey wants more. What else? I'll consider it.
You should be banned from asking any more questions ever for the rest of the.
Well,
For the rest
okay,
of my life.
reasonably speaking, though.
That may be going a little bit too far. But that's already been asked for, by the way. And that the court, in giving these instructions, intends to rebuke the state for asking for eliciting that improper testimony.
So, Your Honor, it wasn't improper testimony. It
Okay.
was the question.
Improper statements of the state. That's the whole point of a rebuke. That's the whole point.
And we would ask that the court if the court is going to read, that the court reads only what the court initially said.
All right, ladies and gentlemen, I've got some further instructions for you with regard to some of what you just heard. So I gave y'all an instruction that if this witness provided testimony that was inconsistent with a guilty plea admission, that you could accept that guilty plea admission as substantive evidence against any of these defendants. But then what we heard was that this witness pled guilty in 2017 to that being a part of that 2015 drive-by shooting. But and we heard kind of a factual basis that the prosecutor in that guilty plea had read before the court, or somebody had read before the court, as a part of what Ms. Love was asking questions about, and she was, kind of reading it from a transcript. All right, here's the thing, is that guilty plea, as I think you heard this witness say, he entered that because he believed it to be in his best interest to do that. And this gets into a whole lot of kind of legal terminology and legal concepts, but there are a couple of different ways that somebody can say, yes, I'm pleading guilty to a crime. And one of them is called an Alford plea. It's just named after a case called Alford. But they're essentially saying, I am going to plead and accept that I'm guilty of this crime, but I am not saying that the facts that the state's putting forward are true. I am just saying I think it's in my best interest to go ahead and resolve it that way. So everything that you heard and that is totally legitimate to do that. And let me also say that Mr. Wright, who was representing this witness at the time, he let the court at that time in 2017 know, hey, this is an Alford plea. He's doing this because it's in his best interest, he believes, to do this. And Mr. Sledge was under no obligation, after his attorney said that, to, even if he got an opportunity to say anything else, to say, yeah, what my lawyer said, to add anything whatsoever to that. So I think there was a question about that, and he didn't, he didn't say anything else. He had no obligation to. He had no requirement to. He had no responsibility to. Okay. So basically what I told you about, you can take those facts and those admissions and consider it against him or anybody else in this trial. When it's an Alford plea, you cannot. So none of that I said was actually true about what you just heard about that 2017 guilty plea to the 2015 drive-by shooting. Okay. So let me think what else. Oh, and you also, need to completely disregard that anybody other than this witness right here, Mr. Sledge, might have pled to anything that had to do with that drive-by shooting. All right. So just entirely erase that from your minds. And I also, at this point, am going to admonish and rebuke you, Miss Love, to pay careful attention to how you ask questions and to what you put before the jury. You should not have put that factual rendition before the jury as anything that this witness admitted to at the time of the 2027 guilty plea. And I'm going to instruct you to refrain from asking improper questions.
Yes, Your Honor. Thank you.
All right. Anything in addition that anybody needs to put before the court right now with regard to those curative instructions? All right. All right. Go ahead, Ms. Love.
Mr. Sledge. Would you tell the jury whether you are familiar with the person by the name of Antonio Sumlin, who goes by the name Obama?
I know of him.
How do you know of him?
Just seeing him around.
Have you ever have you ever hung
we probably
out
been in
with?
the same. We probably been in the same vicinity, but I never hung with him. He never been in a car with me. He never nothing like that.
What about Martinez Arnold?
Yes, I know Martinez Arnold.
How long have you known him?
I've been knowing Martinez Arnold. Whoa, it's been a minute. I can't actually tell you how long, but it's been a minute.
Is he a person that you know who also answers to the name Duke?
Yes.
All right. Is